Hello and welcome to the very first episode of Barwells Solicitors Let's Talk Law, the podcast where we delve into different areas of law, share expert advice and explore the legal matters that impact individuals and businesses throughout East Sussex and beyond. In this series we'll cover topics such as wills, trusts and estate planning, buying and selling property, litigation, personal injury and commercial law. But today we're starting with an area of law that touches so many lives, family law. Whether you're navigating divorce, making arrangements for your children, or dealing with financial disputes, family law can feel overwhelming. Joining me today, two members from our family law team, solicitor Kaylee Doughty and Chartered Legal Executive Josh Elliott-Noy, who's also the head of our family law department. Josh, I understand you'd like to say a few words before we start.
Yeah, I just want to thank everyone for joining us today for our first podcast. Hopefully it's the start of a good series. I just wanted to qualify basically what we're going to discuss today, what we're going to provide information on. We thought about just covering mainly the most common subjects that we get asked about. This one is about divorce and finances, and it's really just to provide information to help parties with the initial steps and some general information regarding resolving these issues. And so, yeah, we hope you find it useful. Greg's going to ask us a series of questions and we'll go from there.
Sounds good. I'll start with the first question. If I was someone seeking a divorce, what are the first steps you would advise I should take?
So one of the first steps I would say is book an appointment with us. We understand that the decision to come to a divorce is a really tricky decision and it takes time to get to that point. So, having that initial advice with myself and Josh, it can really put you on a good footing to know what the divorce process is, what's considered with the matrimonial finances and how they're divided, and it can just kind of ease your mind to know what the legal process is. So divorce process is started by actually drafting the divorce or dissolution application. For this, we require the parties' details. We also require details of the marriage and the fact that the marriage has broken down irretrievably. This just means that the marriage cannot be saved. There's now no fault apportioned to either party, there's no blame. And once we have drafted the divorce or dissolution application, we will usually send it to the other party involved to put them on notice of your intention to actually start the divorce process. Once the divorce application has been filed with the court, there is a £593 court fee upon filing, and the court will then issue the divorce or dissolution application, usually between 1 and 2 weeks after it's filed with the court. You will be given a case number at that point, and then the divorce and dissolution process is pretty much a timetabled event. The other party, so the respondent in a sole divorce or dissolution application, will be notified of the issued divorce application, and they will have 14 days to complete what's called an acknowledgement of service form. If the matters are particularly contentious between parties, then the respondent may decide to either not reply or complete the acknowledgement of service form, or make it more difficult for the divorce to actually proceed. There are several ways that we can get around this, and it's not a barrier. There are various different service methods that we can use to try and get the divorce ball rolling. It is now very difficult for the respondent to defend or object to a divorce application, and if they did so, the court would actually require a hearing for both parties to attend. Assuming that the acknowledgement of service form has been filed on time, the divorce will enter into what's called a 20-week holding period. This time period has extended since the reform of the divorce legislation, and the idea behind it is so that parties have that time to try and work out what the split of the matrimonial finances is going to be later on down the line. After that 20-week holding period has expired, the applicant is able to apply for what's called the conditional order, which is the first stage of the divorce. Once the 20-week holding period has come to an end, the parties are eligible to actually file what's called a consent order. And the consent order will detail the division of the matrimonial finances, and that's something that we'll talk about in a short while. The conditional order is very important because without the conditional order, you cannot apply for a consent order. If there has been any issues with the divorce application, the court may not actually grant the conditional order. It may be that you haven't provided an adequate copy of your marriage certificate, or there was an issue with the timing of service upon the respondent with the divorce application. If that is the case, the court may require a hearing, and so that's why it's incredibly important to try and get that early advice from us that we can guide you through the initial stages of the divorce process. After the conditional order has been granted, the applicant must wait 6 weeks and 1 day before they can apply for what's called the final order of divorce. The final order will actually dissolve the marriage, but it should be noted that it does not sever the matrimonial financial ties that parties hold between one another. The only way to sever these ties is by entering into a consent order, and that's why it's always advisable to resolve the matrimonial finances and obtain a consent order before actually applying for the final order of divorce.
Thank you. What would someone do if they followed all those steps and sorted out their finances, but their husband or wife were refusing to apply for the final order of divorce?
So if you find yourself in a position whereby you are the respondent in the divorce or dissolution application and everything's been sorted, but your husband or wife is refusing to actually finalise the divorce, you as the respondent can actually apply for that final order. So you have a couple of extra hoops to jump through. So you would need to wait 3 months from the date that the applicant could have applied for the final order of divorce. You would need to also provide a reason as to why you are the one that's applying for the final order and not the applicant, and you will have to also pay an additional court fee. The court can also order parties to attend a hearing as well, but just because your husband or wife who is the applicant is refusing, it doesn't necessarily negate the final stage of divorce being completed.
Kaylee, you mentioned that the parties can make a sole or joint application. What does that entail?
So one of the biggest factors that has changed in the recent reform of the divorce legislation is that parties can actually either apply on a sole basis for a divorce or a joint basis. Now, with a sole divorce application, the parties are called applicant and respondent, and it's the applicant who will progress the divorce. They will initially file the divorce application. They will also apply for the conditional orders, that first stage of the divorce, and they will progress it all the way to the final order of divorce as well. With joint applications, the idea behind this is that if parties, they're not at the point where the relationship is totally broken down and communication is totally broken down, they may wish to do it as a joint application, as it provides parties with more control over the stages of the divorce. So the parties in this case are called applicant 1 and 2, and each stage of the divorce has to be approved by the other applicant as well. There are obviously benefits to doing a joint application. As I said, there's probably less acrimony if you're able to come to the decision to do a joint application in the first place. Both parties are in control, and it might be a bit of a united front, as it were. The downside of filing a joint application would be if that communication between parties break down, then you're then in a position whereby one party may actually refuse to progress the divorce.
Right. Are there any practical first steps?
Yeah, so there's a few, mainly which Kaylee's just touched upon. The first one primarily is to locate your marriage certificate, the original marriage certificate. That is needed to be sent off to the divorce courts as soon as you're filing a divorce petition with them. They do go walkabouts, they're quite easy to lose. If you do lose them, then it's not a block to getting a divorce. We can get replacement certificates. If you were married in the UK, then it would just be a matter of contacting the local council from where you got married, provide them details of the dates, parties, names, etc., and we should be able to locate a replacement certificate for a small fee. If you got married outside of the country and you lost your marriage certificate, well, it would be slightly more complicated, but we'd have to contact, or you would have to contact parties in the country where you got married to see what the position is there to obtaining a replacement certificate. The second part really is just making sure that all the contact details you give for the other party are correct. And then finally, the payment of the court fee, which, as Kaylee touched upon, is £593, and that is payable to the court when we're actually filing the divorce petition with them, so it needs to just be held on account in advance of that.
How are matrimonial assets divided up when divorcing?
Yeah, so there's not a set formula. There is not a scientific calculation that sets out who should walk away with what when we're talking about finances on divorce. Most cases will be considered what we call needs-based cases, which is where we are balancing the parties' needs and dividing the assets that are available based upon those needs. Like I said, there isn't a scientific calculation for it, and it's very subjective to each case. The main thing for the parties is to quantify what their needs are in terms of capital needs, such as housing needs, and then also income needs. That can affect the overall division, which I'll touch on shortly as to the train of thought behind that and the law. In terms of practical steps, the first thing really would be to assess what there is to divide. So a bit of a fact find. If you aren't aware of the finances in a marriage, then obtaining that information, which is what we call financial disclosure. That will involve assessing or obtaining valuations for things such as property, anything to do with bank statements, bank accounts, pensions, businesses, anything to do with liabilities, such as loans, credit cards. And the idea being that essentially we can assess what is in the matrimonial pot to divide, and then that's where the law would start to come in terms of applying the needs, which like I say, I'll touch on shortly.
How can parties come to an agreement about how to divide their matrimonial finances?
So there's a few ways that parties can kind of enter into that conversation, and it's really dependent on the parties and what they want out of the negotiations. So one of the first stages that parties might consider is mediation. Now, mediation is, or can be, a really great tool, providing that both parties properly engage in the process. So a mediator will be involved, and they're a neutral third party. So they're there to kind of facilitate the conversation, and it's, without the need to involve solicitors at that stage. Both parties, as I say, need to be really committed in engaging with the mediation process for it to work. We do see it quite often where parties can get quite frustrated because of either lack of engagement from the other party, or they think that the other party is kind of hiding something and they're not being particularly truthful about what assets they might have. So alongside mediation, some of our clients do come to us and we offer ad hoc advice alongside their attendance at mediation. And this can be a way to, kind of smooth out the process with mediation. We're able to kind of offer our thoughts on what questions they should be asking at mediation and how to progress matters forward. One of the biggest things throughout all of these processes is that full and frank disclosure needs to be given by both parties, as Josh just mentioned. And so without that full and frank disclosure, it's going to be really hard to kind of ascertain what's in that matrimonial pot, what's available there for division. So one of the the main things that we can do on an ad hoc basis is making sure and guiding you through to kind of what questions should be asked and what you should be looking out for at mediation. Once you've kind of reached an agreement at mediation, or with the assistance of us kind of acting in the background, the aim is to obviously record things within a consent order. And parties come to us quite often and say, look, we've reached an agreement and we'd like you to draw this up into a consent order, which is perfect. However, we must stress that even though an agreement has been reached between the parties, if it's very heavily one-sided, so it's to the detriment of one party, or it's in one party's favour more so than the others, then even though you've reached that agreement by consent between yourselves with the assistance of mediation, a court can still reject that consent order. The court are, they're concerned with the parties' needs, and if the court believes that the division won't actually meet the housing and income needs of either one party, they can refuse that consent order. Without that full and frank disclosure, it's really hard for any legal professional to be able to say, right, this is what we think the split should be. We're not mind readers, and we need to have that information there to be able to adequately provide you with advice. One of the most common routes I think that we see is assisting parties with the completion of what's called Form Es and providing that financial disclosure that Josh said about earlier. So with that kind of route, both parties complete these forms, gather up their disclosure with the aim of mutually exchanging it with the other side. That way, we're then able to gauge what's actually within the matrimonial pot and what's there for division. This is really at the heart of the negotiation stage because, we've got all the information that we need to build up what's in that matrimonial pot and what assets are there within the matrimonial pot that are available for division. As I say, the division needs to meet the parties' kind of housing and income needs, and usually the starting point for the court will be kind of 50-50 basis to begin with, but that can definitely shift, again, depending on the parties' needs. And whether there's any children involved, the level of the matrimonial pot, and any kind of level of liabilities as well.
What happens if parties cannot agree?
So if parties really cannot agree, then the kind of last resort would be making an application to issue financial remedy proceedings. Now, this really is a last resort option. It is a much more arduous process and can create kind of more conflict between parties. And, it does require preparation for hearings. It requires parties to attend hearings as well. And it's really, as I say, a last resort. And the court would want to see that parties have exhausted options such as mediation, or got that advice from solicitors or tried to negotiate. I think the court have always had this in the background whereby there might be kind of cost consequences for parties if they haven't exhausted all options. But I think we're definitely seeing a rise in that now, whereby if parties are just jumping the gun and kind of just issuing those proceedings, there can be cost consequences for either the party that hasn't engaged, or if parties just haven't engaged in any kind of mediation or negotiation process. So it's not a decision to be taken lightly. We try and avoid it as much as possible.
You mentioned there's no set formula with regards to how the matrimonial finances are divided, but are there any influencing factors that are taken into account?
Yeah, so that's right. So ultimately, when we're talking about dividing finances on divorce, and Kaylee's briefly touched on it there, is that when a judge is looking over an order or trying to reach a decision on the party's behalf if financial proceedings are involved, they'd be looking at whether what they're being asked to approve or the decision they're making, is it fair and reasonable? And that's fair and reasonable in the circumstances, so it's subjective to the parties. What's fair and reasonable in one case isn't fair and reasonable in another. But the marker, the starting point, will generally be equality. So is an equal division fair and reasonable? And then people might look for reasons to depart from that equality. Now, the main law around the division of finances is what's known as the Section 25 factors. So that's something for parties or potential clients to go away and look into, and they'll see various factors there. Some of the main ones that determine the influence of a financial division are the income, earning capacities of the parties, the age of the parties, and the duration of the marriage. For example, with the duration of the marriage, Parties that have been in a long marriage, potentially retirement age, where children are all adult, an equal division may be the fair and reasonable split. Where parties on the flip of that have had a very short marriage, potentially a childless marriage, it may be fair and reasonable that the parties take away from that what they brought to the marriage. A justification for departing from equality, an unequal split, may be more so where one party is going to be the main carer for children. That can obviously have an effect on their income and their earning capacity and their ability to meet their housing needs and their income needs as a result of that. And that then might justify a departure from equality in that person's favour. That's the sort of train of thought that parties go behind or we look into when we're talking about advice on these sorts of subjects.
How would the parties then record the agreement reached? Does it have to be signed off by the court?
Yeah, so this all relates back to the consent order that we were talking about. So don't forget, you can only apply for your consent order once you've got the conditional order of divorce. But the aim with recording everything within a consent order is to provide what's called a clean break between the parties. And that will sever the matrimonial financial ties between the parties. So if parties were not to enter into a consent order, essentially the claims that each party have as a result of actually being married, they remain open and they're not dismissed. So that could be, pose a potential risk to any future property that one party may own, such as a house or, anything such as pensions. They all remain open, the claims, and so there is a risk that you could have been divorced for 10 years and the other party or your ex-husband or wife could still try and make a claim against you. So really, the divorce process is much more complete if you enter into a consent order as well, because that gives you that finality of the divorce and the marriage as well.
How are you able to help during this process?
Yeah, so there's a number of ways that we can help, depending on the client's budget and what they would be happy with in terms of the level of service that they receive from us. So we obviously offer the sort of the full tailored service where we deal with things day to day, deal with all the drafting of documents, etc. Or we can work on a more ad hoc basis where we work in the background. Parties may be more comfortable dealing with things themselves. Potentially that's because they are working to the budget that they have, and we can help in the background, whether that's on specific jobs or just providing advice, potentially once they've exchanged disclosure, reviewing things like that, and then having meetings to discuss what sort of offers may be put forward based upon our views and the law. There's a number of ways that we can work and we can cater to people's budgets. It's really just a matter of reaching out.
And just to add on to what Josh was saying there, so obviously, we've talked quite a lot about divorce and the resolution of matrimonial finances, but, we understand that family law issues aren't just confined to that. So we can provide advice on things such as pre- and post-nuptial agreements, child arrangements, kind of cohabitation agreements, separation agreements between, married or unmarried couples, and also unmarried property disputes as well. Whatever your family law issue, it's always best to try and get that initial advice early on, so then you're armed with the knowledge of how to progress matters forward. With divorce and finances, we completely appreciate that it's going to end up with some big life changes, such as from moving homes to sorting out child arrangements and making sure that you're financially stable after your divorce is concluded. At Barwells, we are able to offer a 30-minute free advice session, and that can be via a video call, a telephone call, or come and meet us in person. Whatever your family law issue, please do get in touch.
And thank you to you both for joining us today and sharing your legal insights.
Thanks very much.
Thank you. Thank you so much for joining us for our first ever episode of Barwells Solicitors Let's Talk Law. If you're watching this on YouTube, be sure to subscribe and hit the notification button so you never miss an episode. And feel free to send us in your questions or topic suggestions. We'd love to hear from you. If you have any legal questions or need some help, our contact details will be appearing on the screen now.